It's been a big day for freedom of expression in very crucial courts that saw important developments. The government revealed in the Bombay High Court today that the fact-check unit introduced in the amendment to IT rules will be constituted only in July. These rules were notified on April 6th. Effectively, the constitution of this fact-check unit seems to be on hold. Meanwhile, the Delhi High Court has quashed Delhi University's decision to debar a student for 1 year because he screened a banned BBC documentary. So why does this matter? In the case of the fact-check unit, there are concerns that the rule which allows this government body to decide what's fake and what's not will have a chilling effect on any speech criticizing the government. Whether this is eventually reined in or more clearly defined remains to be seen. But once again, are we witnessing the role of courts as the last resort for free speech? To speak more on this, I'm joined now by our panel of guests, Tanmay Singh, Senior Litigation Counsel for the Internet Freedom Foundation. They are pushing and they are actually arguing the Kunal Kamra case in court. Tehseen Poonawalla, political analyst, with me on the show. I'm speaking with Abhishek Malhotra, Managing Partner, TMT Law Practice, and Desh Ratan Nigam, lawyer. Welcome to all of you and thank you for speaking with us this evening on Beyond the Headline. Tanmay, let me begin with your take, because the Internet Freedom Foundation has hailed today's development, saying it's effectively putting the constitution of this fact-check unit on hold. But is that truly the case? Because the argument seemed to be that there should be no interim ban or interim stay on the constitution of this fact-check unit, because they're going to frame the rules in July itself, and the next day the court is given June 8th. Why do you see this as a victory today?
Thanks for having me. You're absolutely right. And let's be very fair to the government. It is not an order of stay from the Bombay High Court. The government has come to court today, and on their own accord, they have given an undertaking that they will not constitute the fact-check unit until July, thereby giving the court some time to deliberate on these proceedings and come to a decision. That being said, the fact-check unit is absolutely a problem. And it is a problem for everybody in India, because these rules create an element of the government being the judge in its own cause. Essentially, the government will appoint a committee that will censor content about the government that it has itself deemed fake or false or misleading. Now, these provisions are very vague and very broad, especially when there are no enumerated criteria or clear picture of what it means when it says fake or false or misleading. We just don't know. But this unit will be empowered to decide what is real, what is fake, what is true, what is false, what is the correct picture, and what is misleading. And if you don't agree with them, well, the rules don't provide you any hearing or appeal process or anything. The committee's word is the law. As an intermediary, if you receive such a notice, you must take this content down.
Okay, so just one follow-up over there, Tanmay. What does it effectively mean for the concerns over the fact-check unit? The government can take time to notify rules, right? Just because they have said they want to do this in April doesn't mean they have to immediately put a committee together. So is this giving you hope right now, or does it remain to be seen what eventually happens with this fact-check unit?
Yes, absolutely. So how the rules are structured currently is that they were notified on April 6th. And within the rules, there is a provision for constitution of this fact-check unit as a committee by a subsequent notification. Once the constitution of the committee becomes clear, that is what is on hold. The rules continue to be well and valid, even though without this committee being appointed, the operation is effectively stayed. The problem is that these rules and this committee will directly impact the fundamental right to free speech and press freedom. And it's not just limited to satire or comedy. It just so happens that Mr. Kamra, the petitioner, is a satirist. It applies in equal measure to news stories as well. One of the biggest problems here is that free speech and free expression are at the very heart of a functional, constitutional, and participative democracy. You have to have the right to say something that the government might not like. And this right has reasonable restrictions. I am not for 1 minute saying that there can be no restriction on free speech, but the restriction must be reasonable. What is reasonable? Well, that's enumerated in our constitution under Article 19(2), which says that free speech may be restricted on grounds of security and integrity of the nation, public order, friendly relations with foreign states, etc., etc. It does not say fake or false or misleading anywhere. Immediately, the rules have gone beyond our constitution and are, so to speak, unconstitutional. Now, the matter will proceed to final arguments and a final decision is pending. So we'll wait and watch what happens. It is not for us to speculate on which way the courts will rule.
Absolutely. So that is pending. But, the debate is very much on in public life. Abhishek Malhotra, let me get your view on what we have been saying. One is this fact-check unit on hold at a time when the government is also facing pushback for its amendment to IT rules. And can there be a fact-check unit which the government can decide itself what is true or not when it is the subject?
So very frankly, when you're making an allegation against someone that they have, let's assume in a worst case scenario, defamed you. Now, we all know that the only defense or the best defense to defamation is that the statement was not defamatory because it was the truth, right? So when I, as a complainant, say that a statement that has been published against me or vis-a-vis me is defamatory, I am saying that it is untrue, right? It is a statement made about me. Therefore, I am in a position to say whether it is correct or not. What is the fact check unit going to do? The fact check unit is going to say that a particular statement or a publication carries some statements, either one or more statements, that are untrue. Now, in the event that those statements are untrue, clearly the only reason why I would want to take them down is if there is something which is hurtful from a defamatory standpoint in relation to an agency or makes an allegation which is untrue, etc., and shows that entity or institution in a bad light. The institution certainly has the right to get up and say, hey, this particular statement or set of statements is incorrect. Now, at the end of the day, we are talking about a situation of an intermediary liability or intermediary safe harbor. Intermediary is supposed to publish terms and conditions to say, look, you users who are using my platform need to follow certain parameters and certain aspects of the law. One among them being that please do not put out a statement which is incorrect onto my platform. Because if you do that, then you are basically putting me in a position where if I receive a statement that this is an incorrect statement, I need to take it down. Now, it's not as if there's no remedy to this. If this happens and the intermediary takes down the content, the person who has put out the content, the publisher of that content, has every right to approach a court of law and say, look, this is incorrect. I have basis to say that the statement that I have made is correct. I do not understand what the problem is.
So Mr. Malhotra, is that practical though? Is that practical? I know we've started this entire show with a lot of legalese because, we want to set the facts in place. But let's be honest about what this is going to do. And these amendments and this fact-check unit will talk only about stuff pertaining to the government business. It's not protecting everyone, or it's not protecting against all fake news, which is a lot floating out there. Okay, Tehseen wants to come in. Yes, Tehseen.
In the show, and at the onset, many congratulations to the Internet Foundation and to Tanmay Singh for this fantastic victory. Kapil Sibal, G and I, we were going to move the Honorable Delhi High Court, but you all had moved Bombay High Court, and we did move High Court for this. And the student who we helped, Lokesh, that was Kapil Sibal Ji and Insaf Foundation did that in Delhi High Court. So I want to first come to this fact-checking unit. As Tanmay said, the government cannot be a judge in its own case. Please look at the chilling effect, Tamanna. One, with respect to Abhishek Ji, a government cannot sue you for defamation. A government can definitely clarify individuals. If individual statement is made against somebody, say I accuse somebody of taking a bribe of 50 crores, individuals can. Government can't file defamation cases against people. So now the government already has recourse to say if there's a news is fake, to put out the correct news. The chilling effect in this was the government would order, pressurize the intermediary, for example, Twitter or Instagram or etc., to take down that news. Now, if a journalist, you Tamanna, hypothetically broke a story that in the midday meals there is roti and salt being served, not the complete food, and the government, in its interest to protect itself, says no, Tamanna's story is wrong. We are serving an absolute meal, and now the onus is on Tamanna to go to court and prove her story because it's in the government's interest to put her story down. How is anyone going to do it? So this completely kills the idea of journalism, apart from censoring artists, censoring other people. This would kill journalism as we know in India. So grateful to the Bombay High Court for stepping up and to the courts for stepping up. To the other story about Lokesh and moving court on the BBC
Right.
documentary. Okay, so somebody saw a documentary which the government said should not be seen. You can't ask the person not to submit his thesis. He wasn't even present at the time in the university. There's something that's come on WhatsApp. And the effect that this government is having, that if you do not toe our line, first of all, this matter of this documentary sub judice in the court. The government, in my opinion, has absolutely done an illegal act in banning this document. There's no basis of banning it. It's gone and said in court, we've not banned the documentary. Mind you, it's played a technical, in the courts, it said we've not banned the documentary. Where we all know the documentary is not allowed to be there. And then you go and say, oh, but somebody's mobile, this documentary is there. We will not allow you to serve your thesis. The fact is that this is an insecure government. When governments tend to become authoritarian, they do not tolerate dissent. The basis of our democracy is dissent. I may not like this government, and I have an absolute right to come out and be critical of this government. The government cannot haul me up, put me in jail,
Right.
not allow me to submit my thesis, not allow me to make my presentations, only because the government does not think that my conversation is uncomfortable to them. And I think that is something that we need to be guarded about very, very strongly.
So, are the courts now the resort for this? Desh Ratan Nigam, this entire debate, this entire conversation has been going on for several years. And this fact-check unit just seems like the latest in an attempt to quell voices of dissent. It's unlikely that if someone puts out a post or any kind of information about the government, which may not be true but makes it look good, that the fact-check unit will step in and say, no, we didn't do such great work, remove it.
Tamanna, let us make our focus on false and fake news, not about dissent. Dissent is allowed so far as the news is not fake and not false. Knowingly, if you are trying to promote something which is false and fake, you want to be taken to court, or you need to develop a system where a person can be taken to task. So focus need not be taken away from false and fake news. Here, the fact-checking unit is about the central government. And the central government will be able to tell you whether it is fake or not. So what we are saying, what is the check and balances? So that the government doesn't decide tomorrow that that true news itself is being, declared as a false. So that is, we should discuss. They will have a power. Do we have a mechanism, such kind of situation where the government gives the false statement? Yes, we have a system of judicial review, like Kunal Kamra had gone at the judicial review of the Bombay High Court. Similarly, everybody has the right to approach the court. Yes, the fact-checking unit will give notice. Notice will tell you this is false news or false information. So therefore, you have ample time to your stand before the central government, and the government will then pass an order. That order is challengeable in a court of law under judicial review through a 226 petition. So therefore, there are ample facts
Okay.
and checks and balances.
No, but that's an important distinction. 1 minute. Tehseen, let me come to that. The important distinction is not about criticism. It's about what's true and what's not true. So
Yeah.
who is going to safeguard against that?
Tamanna, who decides what is fake news in
ultimately-
case of the central government? The central government or the union government itself will decide whether the news against them is fake or no. So let me give a hypothetical situation to explain this to your viewers. Let's say Mirror Now puts out a story. The union government thinks the story is not correct. Mirror Now will give them a platform to put the story out to clarify. How can the union government pressurize Tamanna or Mirror Now to take down the story? If Mirror Now stands by its story or you, Tamanna, stand by your story, can the government pressurize you? And therefore, the remedy is already there with the government. If the government believes this is the story is not true, the government can put its clarification. How can it force the intermediary to remove the story? And the government is a judge in its own court. That is a violation of Article 14, the right to equality.
Can I
Nobody
come
can be a
in?
judge in their own court. The government has no right to judge its own court. This fact-checking unit comes under the PIB, which comes under the Ministry of Information and Broadcasting, which comes under the Union Ministry. So there'll be no bad news against the government, because in every case they will lose. Hey, this story is wrong. We are right, and you have to take it
But
down.
the purview is beyond
Can I come in?
journalism. The purview is beyond journalism.
Can I-
They're talking
can I
about
come in?
parody, jokes, satire. Yes,
Everything.
Mr. Nigam.
Yes, let me
Mr.
come
Nigam.
in. I think
Yes,
I
yes,
think
sir.
it is for your viewers to know that almost all the cases, whether it's customs, income tax, it's the government authorities decide, pass an order. And when they pass an order, it is challengeable in a court of law, either through judicial review or the provisions within the Act. To say that government cannot get judged in their own cause is absolutely wrong, because all the agencies of the government pass orders. And they being a judge in their cause, but they are challengeable in a court of law. So therefore, to say that government cannot decide and do not have the powers is absolutely a fallacious argument. Yes,
Sir,
government cannot be final arbiter so far as the courts are concerned. Can't
sir,
take
income tax is
So
not
then,
a fundamental
one
right.
sec. Okay, one
Income
second.
tax is not a fundamental right. Free speech
No,
is a
one
fundamental
sec.
right. Journalism is a fundamental right.
Let's put this to the test of practicality. I asked that question to Abhishek Malhotra earlier, and I'll come back to you on that. So you're saying, forget about journalism and a professional journalist, a news channel, etc. Someone, right now you have so many citizen journalists. Everyone has their point of view. Everyone wants to talk about, what they think, etc. If a citizen has observed something that has bothered them, wants to put out a post, a tweet, etc., and it gets flagged by the FCU, the fact check unit. Are you saying an average citizen will then go and challenge this in court, that why did you take my post down? Is that
Tamanna, it's
likely to
very
happen,
important.
Mr. Malhotra?
Yeah, so Tamanna, very important, because all of these discussions are being carried out without giving the context to what we are talking about. Let's assume we did not have the internet. What were the platforms on which any such views or aspects were ever aired? These were the platforms of paper news publications, and later radio and television. Now, are you saying that the platform which is being used to air a particular statement or an opinion will not try to verify the veracity of that statement? They obviously will always go and do that before they put it out. Today, the internet has provided us with the facility of a free and accessible platform where anyone can say whatever they like to. Now, and very frankly, people, perhaps Internet Frontier Foundation will probably, back me up on this. One of the seminal judgments of this country in relation to the freedom of speech and expression is the Shreya Singhal case. Even in that case, Justice Nariman very, very clearly said, you cannot put press and television at the same pedestal as the internet, primarily because of the speed of proliferation of ideas and contents and opinions on that. The impact that something that is put out on the internet has is huge, is massive. That is the reason why there is development of the law to address a situation and to control something which the government is entitled to do under Article 19.2. Yes, there is freedom of speech and expression under 19.1a, but 19.2 says that there are reasonable restrictions that can be put on such a freedom of speech and expression. And this is an example of such reasonable restriction. No one went to court when the original provision, now this is an amended provision, right, that we are talking about. I have the original provision of the IT rules with me, which say that what you cannot put out on an intermediary platform is stuff that is patently false and untrue and is written or published in any form with the intent to mislead or harass a person, entity, or agency for financial gain or to cause any injury to any person. Who will decide whether there is an injury? Who will decide whether there is patent falsity and untruthfulness? Of course, the person who's making the allegation. If it is about something to do with the central government or any government, it is the government which is going to come and say that, look, this is something which is false.
I thought the idea was to protect the average citizen and not just the government.
Undoubtedly. But my point is that as part of protection of the average citizen, you have to have a balance. As what Mr. Nigam said, there has to be checks and balances. One of the check and balance is that this is something which is where the government is going to send a notice to the intermediary. Please, this is a non-factual statement. Please take it down. Now, over a period of time, right now, and as I said in the previous interview also, I think we are jumping the gun. Over a period of time, if let's assume that the government says arbitrarily that this is an incorrect fact, take it down. Someone goes and challenges it, maybe not the first time, maybe the second or third time. Someone goes and challenges it, and the government cannot substantiate why that was an wrongful statement. then of course there will have to be guidelines developed by that same very government or under direction of the court to say that statement by the fact check unit has to be backed up by reasons. And that's what Mr. Nigam was talking about in the issue
Tanmay wants to come in.
review.
Tanmay wants to come in. I just want to point out something Elon Musk was quoted as having said recently in an interview in connection with guidelines of taking down content on Twitter and India. And he said, he was quoted as having said in an interview to an international organization, news organization, that it's better to take stuff down than go to prison. So the idea that it's going to be the social media intermediaries that will stand up for freedom of expression in a market where their idea is to be in a thriving business. They're not here for philanthropy. They're here to make money. That's why they want to be in India. Are they going to cross swords with any government of the day? And is that one of the concerns? I want Tanmay Singh to respond to some of the points Abhishek Malhotra made. Yes, Tanmay. Are you in mute?
Yeah,
Yes.
apologies for that. Abhijit, at the risk of fact-checking you myself, let me just say that the unamended rules actually have been challenged. They were challenged in about 6 or so high courts by about 17 or so different petitions. On the 14th of August 2021, Part 3, which related more to digital news publishers and OTT platforms, were stayed by the Bombay High Court. This was followed up by an affirming stay.
Wasn't challenged.
Sir, let me please. There was a follow-on affirming stay by the Madras High Court in TM Krishna versus Union of India, which challenged the entirety of the IT rules 2021, actually, including Part 2, which relates to social media intermediaries, including the rule that you were referring to. And the Madras High Court there has made some observations about those rules. There are transfer petitions pending in the Supreme Courts, and we'll see where they go. But it wouldn't be correct to state that they have not been challenged. Coming to whether we can expect platforms to ensure that no misinformation is spoken on their platforms. Yes, absolutely, we must. But to make that a legal requirement enters into the realm of freedom of speech and expression, because then you're delegating censorship from you upon these intermediaries, which is exactly what Tamanna was referring to with Mr. Musk's statement. If you're aware, about 34 million Indians are on Twitter, and they generate millions of tweets and speech content on the platform on a daily basis, and it would be frankly impossible practically and logistically to expect them to make sure that it is completely free from misinformation. But that's on the practical aspect of it. On the constitutional aspect of it, you mentioned reasonable restrictions, and I absolutely agree with you. It's just that the Constitution doesn't. 19.2, which enumerates the reasonable restrictions, doesn't actually say anything about information that is fake or false or misleading. So that's a direct impact on fundamental speech. On Shreya Singhal, actually, that's a fantastic opportunity for us to talk a little bit about the procedure of things. I think a lot has been said so far about the government or the fact-check unit issuing an order that you can then take to court and challenge under Article 226 or 32 of the Constitution. But actually, that's not how it has been working in practice. So if you see the blocking rules of 2009, which under Rule 8 require the government, which specifically the Ministry of Electronics and Information Technology, to give a notice and a hearing to any person whose information is taken down. And this information could be a website or a tweet or a Facebook status or anything like that. They're required to give them a notice and a hearing. This was specifically noticed by Justice Nariman in the Shreya Singhal judgment in 2015. Which he noticed, and he said, okay, there are procedural safeguards, and on the basis of that, he held them to be constitutionally valid. But we've seen practically that the government does not actually do that. People have had to go to court not to challenge the order, but to actually be able to receive a copy of the order so that they can challenge it afterwards. You may have a look at Tanur Thakur versus Union of India that is currently ongoing in the Delhi High Court for more on that. Currently in the rules, there doesn't appear to be anything to suggest that the FCU will provide any intermediary or any person a copy of this order designating their information as fake or false or misleading to enable them to challenge these things. And in the absence of that, combined with the fact that in places where those rules actually do exist and are routinely and consistently not followed, it becomes very difficult to sustain the presumption that notice or orders will be provided in this case.
Yeah, Abhishek, you wanted to respond, Mr. Malhotra?
Can I come in?
Just very. Just very
I will
quickly,
come. I will come. But
points.
just because Mr. Malhotra wanted to interject, yes.
Yeah, just 2-3 points. Whereas other provisions of the IT rules of 2021 have been challenged, including the entire structure of appeals going up to the interministerial committee, and also the aspect of who can govern what part of the regulations. However, the regulation that I read out is from Rule 3, which actually is a reproduction of the regulation that was there even in 2011. So it's not anything which is new, very frankly. Secondly, the aspect of I very well said that it's not as if the fact check unit can run riot forever and ever. It is not going to be uncontrolled or untrammeled kind of power. Let's assume that it does do something for the first 2 or 3 times and then it gets checked by directions of the court. Ultimately, there will have to be a basis for the government to stand behind its allegation that this is an incorrect statement. So, as I said, it's not as if the rules do not have any basis. I mean, when you say that 19.2 does not provide for this sort of a thing, there are broad heads under 19.2. There is defamation, there's public order, there is let's assume that a statement is made with regard to something to do with the friendly relations of the state. That is also under 19.2. So the specific provision does not need to do a copy paste of 19.2. It's an extension, it's an interpretation of that. It's an evolution of law.
Let me just bring this debate a little away from the legalese, because what is all of this going to eventually do for the people of this country? People watching this must be wondering, okay, lawyers to apni baatein kar rahe hain, court mein kuch chal raha hai. Why does it matter? I think we have a responsibility to tell people why this matters and why have we picked up this subject. One interesting example, Tanmay, is like, I'm sorry, I'm going to fact check you, but there's no terrible repercussion for you, Mr. Malhotra, for being fact checked. The question is the repercussion. Can that fact check have a chilling effect on speech? Will people self-censor? And that really is the concern, isn't it, Tehseen?
Absolutely. But just make a quick legal point before I come to the political point. You see, one thing Mr. Malhotra sort of missed out. Section 79 of the IT Act 2000 is protected by the Supreme Court, even in Shreya Singhal. It is protected. So no intermediary can be held responsible for content going from it because it's posted by somebody else until it is shown or proved that the intermediary colluded to spread that news. So intermediaries are anyways protected. This is the Supreme Court two-judge judgment in Shreya Singhal and by law. So the government tried to intimidate Twitter, Instagram. So this is very important. The effect of this is self-censorship, Tamanna. Here is somebody. Let's go to the second case. On WhatsApp, I get a documentary about the Honorable Prime Minister, BBC documentary, which, believe me, the government says in Supreme Court we've not banned, but we all know that the documentary is not being allowed to see. Now it's on my WhatsApp. Somebody sent it, maybe somebody kind like Mr. Malhotra sent it to me, who perhaps may be supporting the union government. And now goes there and makes a complaint. Look, he has it on his WhatsApp, and I'm not allowed to give my thesis. So I now have to go to the High Court and prove that, listen, I should be allowed to give my thesis. Where does this take our country? Free speech must allow you the liberty to air rather than the liberty to censor. If something is, if there is erroneous free speech, the government can always control it because the balance of power is in the hands of the government. Individuals cannot be running to court. If every individual has to run to court, as Mr. Malhotra suggests, to get his or her right to free speech, we might as well give away our constitution. The reason we fought for independence is the right to be critiqued, not to go to court against our government. I have an absolute right to critique my government. And I repeat, Mr. Malhotra,
but do you have the right to say things which are not true? 1 minute, Tehseen, before I go to Desh Ratan Nigam, that's the point he started with. Critique is fine. Do you have the right to say something that is not true?
So put out the truth.
Because you don't like someone.
So put out the truth.
To say something that is not true.
Has anyone been persecuted for hate speech? The government, in my case, said hate speech laws should come in. It's my case. Has anyone been prosecuted? Yesterday, the Honorable Home Minister in Karnataka said if his political party is not elected, there'll be riots. Has he been prosecuted? Has Pragya Thakur in my FIR, despite the Supreme Court and my name saying hate speech should be prosecuted, the FIR was filed against her? The government will not prosecute anyone for hate speech, but will victimize innocent citizens for what they believe is not fake news. If something is fake news, the government has all the remedies to clarify. The government cannot be the judge on its own case. That does
Desh
not
Ratan
work.
Nigam,
That
you
is
wanted to come in.
The principle of
Desh Ratan
democracy.
Nigam wants to come in. Yes, please respond. Yes, please respond, sir.
I think everybody on the panel agrees that fake news and false information cannot be given a free run. But we are talking about how to have the checks and balances. That is what we are discussing. And nobody will say, if anybody with malified intention and deliberately puts a fake news or a false information, that person needs to be punished and should be punished because it may have grave consequences. And that is what the government is doing. Government initially never wanted to regulate social media or intermediate OTT platform. They went in for self-regulation because if you see ethics rules of 2021, they're mostly about self-regulation. Then the government comes at the stage of the committee and the appellate stage. So when that did not work, then this 2023 rules have come. So government wanted to be, kept itself away from it. But when the duties and responsibilities of citizens, especially of those who are peddling fake news or false information, they do not realize their own duties and responsibilities because it starts from the citizens. It does not start from the central government or about their own agencies. They are only concerned about the news concerning them. But the duties and responsibilities of citizens are also paramount. If they think that they can peddle fake news deliberately, then what is the recourse available? There has to be a mechanism to punish such people.
I want to just give an example which removes the debate from the realm of government and fact-check unit to the broader issue. And I'll come to you with this Desh Ratan Nigam. I'm not taking specific names, but recently there was a post that went viral by an influencer who questioned the claims of a health drink that says it's very healthy. He did a post where he said it's not healthy, it's terrible, right? He faced legal action. He had to take it down. He had to apologize. He is an influencer who has some following. This is a massive conglomerate. The story is still going on because now it became so big that it's become difficult to ignore. And people want to know if those claims were true or not. Now, in a case like this is a conglomerate. This is one influencer. He's not going to take on the might of a corporate. Do you envision a situation where an individual citizen will take on the might of the government? No matter which government. Remember, once these rules are made, we're stuck with them.
Yes, no doubt. Governments pass orders. And every day the governments are passing orders. Under one act or the other, or even otherwise, but the courts have read that the reasonable notice has to be given and the reasoned order has to be given. And that is challengeable in a court of law. Government has always been a judge in its own cause because government is running the country. Government, in fact, gets sometimes aggrieved and sometimes also is at the receiving end. So there are situations here in this country, and this is all under the law. It is not without the permission of the law, they are passing orders because government agencies are supposed to do it. And then you have the final arbiter, which is our judicial system. And in and out, this happens in a country where, and obviously governments have to act within the 4 parameters of the law under which they are working. And therefore, under the ethics rules of 2023, what they are saying is that this is a false news or a false information, and you have been put to notice. You come and answer, and if we don't find it, we'll pass an order, bring it down, take it down, or whatever under the law which is permissible.
Who will answer? The person who's posted the information or the social media intermediary? You've made the intermediary. You've made the intermediary answerable. And that's where the issue comes. You made the intermediary answerable who has no reason to say that, and to defend the person who's posted. They just want to make sure they have smooth sailing in this country. Most of them are MNCs, American companies. Yes.
Let me answer, Tamara. In fact, once an order is passed, either the direction is given to social media intermediary to take it down. If they don't do it and challenge in a court of law, it's fine, the courts take over. And the individual is also supposed to take it down, remove his own post. If they don't want to, and they are still right, then they have to go to the court. This is how democracy functions. Government passes an order, then those are challengeable. This is how democracy functions.
Yeah.
Can I just come in also? Sorry.
Let's give a very practical example. Let's say I tweet something that the government believes is fake news. The government has all the right to individually, if it is fake news that leads to some sort of harm, to prosecute me. Those laws already exist in the IPC and CRPC. Nobody's talking about that. What we're talking about is, for example, now let me go back to journalists or anything, or a joke that the government does not like, or a report that the government does not like. It orders be intimidatory to take it down when they're protected by Shreya Singhal. We're protected under Section 79 of the IT Act 2000. They've been protected. So what the government is doing is saying, hey, we will not allow any news, any information to surface. You kill the source of the information you kill the carrier of the information when they've been protected. That with media already, as some say under government pressure, will have no source of any news against the government. Why is the government so afraid? If there is fake news, like I said, the government has enough recourse to put out the truth or to prosecute the person who's put out the fake news. Why does it have to go after the intermediary? It's only going after the intermediary because, like the government controls mainstream media in most sections, it wants to control social media. That is the fear that we have.
Okay. Tanmay, you wanted to come in. Yes.
Yeah, in one sentence, let me just connect what Tehseen is saying right now about the fact check unit to the other topic that we're talking about, which is the BBC documentary. And this will be interesting to your viewers, which is that in banning this documentary, the government has not actually sent a notice that we know of to BBC or anybody else who has uploaded the documentary. What it has done is that it has sent notices to Twitter and YouTube saying, we note that such a documentary is available for viewing on your platform. Kindly take it down. Far as we know, the platforms took it down, no further questions asked. How that affects the individual person's freedom of speech when censorship is delegated to private corporations, I think that's worth thinking about. I think that's worth talking about. Coming to what Mr. Nigam was speaking about with the notice and the hearing that you will have a chance to be heard with the fact check unit. If that were to happen, if that was baked into the rules and if that was baked into real practice, that honestly, that would be great. It wouldn't still be constitutional because the principles of natural justice and of the constitution would nevertheless be violated, but we would still be in a much better position than we are right now. It's just that unfortunately that doesn't happen. I have some numbers for you. In 2021, in an RTI, the IT ministry revealed that it had blocked 6,096 URLs. And how many hearings did it hold? 39. Which means that on average, it looked at more than 150 URLs per meeting. And guess how many of those meetings or hearings came to the conclusion that, sorry, we made a mistake, these don't need to be taken down? Not one.
Many URLs don't turn up also. Many URLs don't even turn up for hearing, despite notice. So governments have to look in.
No,
Abhishek Malhotra
no, sir,
wants to come
I must tell you that they don't get the notices. So it's not a question of turning up or not turning up. They're not.
Yeah, the notices don't come. That's true. The notices don't come.
Okay, 1 minute. Abhishek Malhotra.
Abhishek
Malhotra. The concern, okay, before you answer, sir, if I can just, set the context. I don't think there's anybody who says fake news should have a free hand. Nobody is going to say, give fake news a free hand. But the question is the balance of power too lopsided with these new rules? Yes, Mr. Malhotra.
All right. So I'll answer that question and connect it to that, just clarify the position a little bit. First of all, just wanted to clarify that the basis for the Delhi High Court to set aside the ban on that student from Delhi University was not on the aspect of freedom of speech and expression. It was on the lack of principles of natural justice because that person was not given an opportunity to be heard. Very constitutional provision. And I think therefore that the other aspect of whether or not it was on WhatsApp, whether he publicized it, etc., that has not even been gone into. So let's just get that straight first. Second aspect is that, the point that you put to me in terms of the context, the government, by putting this out in the intermediary rules, is saying what? It is saying that contrary to what Mr. Poonawalla said, if I'm making a statement which is false and it impacts the government, take me to court, initiate criminal prosecution against me. Yes, the government has the wherewithal to do that. But in the first instance, because the intermediary gets that protection, statutory protection under 79, the government says, look, without delving into the issue of criminal prosecution and taking you to court and harassing you, and because I have perhaps unlimited resources to come after you and to prosecute you for times to come, I'm giving an opportunity to say, I am backing up my statement that this is a false news or false statement that is made. I'm telling the intermediary, who is supposed to be only a pipe. It is an indeterminate pipe which does not make any decisions. I'm telling the intermediary, this is a wrong statement, take it down. Intermediary has two options. In retaining its intermediary safe harbor, it says, I'm going to act in accordance with that. I'm going to take it down in 72 hours. Intermediary has a second option. Intermediary says, I cannot decide in the absence of anything which is substantively put to me as to whether or not this is a false statement. If today, and I'm telling you, this is something that happened yesterday. On behalf of a client, I sent out a notice to YouTube for something which is a defamatory piece of news on their website. I get a response from YouTube saying, we are not in a position to verify whether this is defamatory or not. Please go to court and get an order. Right? So we are looking at a situation. Yeah,
but Mr. Malhotra, your client is the government of India, suppose. And will YouTube stick its neck out?
So
will YouTube stick its neck out?
The question here is, yes, it is a practical perspective to be looked at, but we are not, the people who have impugned these regulations in court are not doing it on the basis of impracticality. They are doing it on the basis of legality. And if we are to look at legality...
That's how it works in court, right? The absolute effect is practical. But you're not going to go to court and give examples. I have to wrap up this discussion, but frankly, I think there is a lot to break down. And we can go on and on with all of this because it has such far-reaching repercussions. Thank you to all of you for joining us in the conversation. But I am going to take a break because exciting stuff is coming up on the other side.